If not, if you don't want to share, that's okay. We'll just continue on with the generally people are looking to protect their kids. For me, my sister is really important to me and my fiance. I don't have kids yet, so protecting them in the case of anything were to happen to me. I know I have a life insurance policy on myself, so that I know my sister and my fiance would be protected if anything were to happen to me. So you're in the right place if you did a fill in the blank will, but you're not sure if it will work. You are nervous about how much it will cost. Um, Next one is because the reality is estate planning is not about you, it's about the people you love most. And it's your loved ones will know whether you lived up to your promise. I took care of it. It's very common that when you're no longer there, there's a big mess that's left for the people you care about, especially if you have things such as a house or children that you are looking after. What you will learn today: how loved ones can cope with the unexpected from two different perspectives. The before. So this is what if you have no estate plan or only a document here or there. And the after. This is the experience is you have a personalized estate plan that is tailored to you and your family. So, and all the details about how to start, how long it will take, and how much it will cost. So right now we ask our attendees to really consider who needs your protection. And if you feel comfortable, you can answer in the chat box. If not, I've given some of my examples of, who is important for me, even though I don't have children personally right now. There are many people that I want to protect and, keep out of court and conflict. So we are going to now welcome the Bliss family. Uh, this is the Bliss family. We have Mark and Molly, Alexander, Benjamin, and Caroline. If you have any questions as we go, please feel free to ask them. You can put them in the Q&A box or write them down. So we have Mark and Molly, who are happily married. They own their lovely home in California, and they have two wonderful children, Benjamin, who is 12, and Caroline, who is 10. Molly also has a child from a previous marriage, Alexander. So this family in particular has put all of their, they have joint checking accounts. They are putting away money for retirement. They both have life insurance to make sure there's financial resources there if one of them were to pass. And they both came into the marriage with a little bit of savings already. They each have a solely owned investment account. And in Molly's solo account in particular, she also has an inheritance from her parents who passed away. But they've never had a need to touch that money, so Molly's inheritance is still sitting in that account. So they also have two pets, Rio and Whiskers. The Bliss family loves their dog and cat Whiskers, of course. Who doesn't love their pet? And then, of course, there is the ex, the father of Alexander, in our story. So this is kind of the backstory to what is going to be happening with our Bliss family. So, we have for Alexander, as a result of the divorce between Javier and Molly, Javier updated his life insurance policy, and he doesn't want the 1 million policy to go to his payable to Molly, and now ex-wife, he wants it payable directly to his one child, his son, Alexander. So Javier made that update on his life insurance. And Javier, in our scenario, is not the most responsible person on the planet, and probably the only responsible thing that he did in his life was getting the $1 million life insurance for Alexander. The Bliss family also has their vacation home, which Molly got as part of her settlement in her divorce. The Bliss family visits vacation home once or twice a year. So this is probably, I think, what you would imagine you're pretty much an everyday sort of family. But in this scenario, we're going to see what might happen if things were not to go quite so well for them and they have a very, very bad, not so good day. Uh, so the sad days are ahead. This is what would occur to this family if something might were to happen to them. And as a side note, I hope you can get a sense of how I approach this topic of life and death. I don't take myself too personally, and I enjoy humor. I want to make sure that I'm conveying these really important points and teaching you and educating you as part of the process. Okay, so turning to sad day number one. On sad day number one, Javier is turning 40. This is his big birthday, and he wants to do something he's never done before. And Javier, being a kind of adrenaline junkie, decides that he wants to go skydiving. So on his 40th birthday, he steps into the plane to go skydiving, but he's just so beside himself with excitement, he doesn't pay attention to the safety instructions, and before you know it, he's jumping out of the airplane before they even finish getting him ready with the parachute and backpack. All of a sudden, it's a skydiving gone wrong scenario. So we know that Javier did not make it through the life and death experience of the skydiving. But he did do one responsible thing. He had the life insurance policy. So the life insurance policy had Alexander as a beneficiary. Well, we might think this is a good plan, right? We have a life insurance policy. We have Alexander as a beneficiary. Great, wonderful. So Javier thought he had a plan, so to speak, by buying a life insurance policy. But what's about to unfold is anything but a decent plan for Alexander. So now we have Alexander is only 15 and he is a minor. So Alexander is actually pretty pumped. He is a teenage millionaire and he is really excited about that very fancy red car he's about to buy. In the meantime, Molly, as you might imagine, is nervous. She's thinking to herself, wait a minute, Alexander is only 15. $1 million is a lot of money. Can he be in charge of his own money at age 15? How can I make sure he's responsible with the money? He's still a teenager and needs to learn some financial lessons and responsibility. So, in this instance, Molly calls our office and lets us know this is going on. Um, and now we are gone into probate court. We deliver Molly the bad news that we have to go to probate court to figure out who is going to be in charge of the $1 million until Alexander is an adult, meaning 18 years old. Probate is required because minors Alexander is a minor, and minors can't be in charge of their money, whether they are 6 months old or 16 years old. Not until they're at least 18, or in some cases, 21, so a judge must figure out who is in charge of the money in the meantime. Molly wants that to be her, of course, because she's Alexander's mom. As part of the process, we have to submit Molly's credit report and background check to the judge, which she considers invasive, but she has no choice. The judge, a stranger, wants to see these things to make sure that she is a seemingly responsible person. Um, and if the child is 12 years or older, they're also going to court, and they could be and often are questioned by the judge as well. So, by the way, everything about this court proceeding is public record that can be searched by anyone, and it takes time. We're on the course timetable, and this can take weeks or months, depending on how fast the judicial process is moving, but it's never fast. And guess who else shows up? Zachary, Javier's brother. This is Javier's life insurance money, you know. I doubt Javier would want Molly, his ex, managing it. It seems like he would rather his brother Zachary manage it for Alexander. Ah, so I have a question for you. Who will the judge choose as Alexander's, quote, financial conservator? Molly, Alexander's mom, or Zachary, Alexander's uncle? The financial conservator will manage the money for Alexander until he is 18. Tell me what you think in the chat box. Who do you think will be appointed as Alexander's conservator? Yes, yes, yeah. The mom makes sense. Yeah, that's generally what people feel. But the answer is we don't know. There is no legal requirement that the conservator be the surviving parent, and there is no legal requirement that the conservator be a blood relative of the deceased person from whom the money comes. The judge has no clue who is actually a responsible adult because uh, it's not their money, it's Alexander's money. And the judge needs to make sure the conservator is going to be responsible with it because he or she will have access to the money. But they're supposed to use it only for Alexander, not vacations or fancy boats. Molly is shocked because she knows she would never do that. She thought this was going to be easy and that she'll just be the default conservator because she's Alexander's mom. But there is no default. And whoever the judge appoints will serve until Alexander is 18, because then he is an adult. So all of a sudden, you have an 18-year-old in charge of a lot of money. No oversight, no financial understanding required, no requirement to check in with anybody. He can do with it what he wants. Imagine, imagine what he'll spend his life insurance policy on when he's 18. So let's do something better for the Bliss family. Remember, Javier thought he had a plan because he had life insurance and because he had named his son Alexander as primary beneficiary. He did not know or realize what all would be entailed in this case if Alexander was a minor and that he was throwing his son into a court system. Let's fix these issues. Number one, Javier decides to leave the money directly to his responsible brother, to Zachary, or responsible or not, we're not sure. He thinks this is an easy, quick way to fix this. Lesson learned, don't name a minor as the beneficiary. But, and this is a huge takeaway, never do this. You don't ever want to name anyone as a beneficiary who you wouldn't want to truly receive the money without any restrictions attached. Javier doesn't really want Zachary to receive the money. He wants Alexander to. He is just thinking he can get around probate easily. So, idea number two, Zachary is not okay. Zachary is not required to use the money for Alexander because it is Zachary's money. If Zachary is the beneficiary, it is Zachary's money. As simple as that. If Zachary wants to use the money for Alexander, great. If Zachary wants to use it for himself, great. He gets to decide because it's his money. And because it is Zachary's money, it is exposed to his lawsuits, creditors, and possibly a potential ex-spouse. So if Zachary goes through anything in his life where he might owe someone else money, maybe he owes to someone who sues him, the creditor, an ex-spouse, then because Zachary has ownership of all this money, someone else who Alexander doesn't even know can garnish the money directly from Zachary, leaving nothing for Alexander. Then Alexander is completely out of luck. None of these people have anything to do with Alexander or what Javier wanted for Alexander. It doesn't seem fair at all. Idea number two. Instead, Javier signs a simple will that says, I leave everything to Alexander. If he is under 21, I put Zachary in charge. Everyone has probably heard you need a will. So that sounds like it will be a good plan. And not only is he saying everything goes to Alexander, but also that if Alexander is not Even under 18, but under 21, then Zachary is in charge of managing the money for Alexander in the meantime. But there's a hole in this plan that I think will surprise you. Javier did not know that at the end of the day, two simple things override your will. Joint ownership and beneficiary designations override your will. I will give you fair warning. I'm about to go through this slide with the most words of all the slides, but there is a good reason, I promise. So let's talk about these three buckets: joint ownership, beneficiary designations, and your will. So here's the thing. When someone calls me after a loved one has passed away, the first thing I want to know after is not whether they have a will. I first want to know whether they have any jointly owned assets with anyone else. Because if they jointly owned anything and that joint owner is still living, the surviving joint owner, in most cases, I won't go into the exceptions, the surviving joint owner is going to get the asset regardless of Javier's will. Let's say that Javier remarried. He owned a home prior to marriage, and then he added his new wife, which is Alexander's stepmom, to title. If Javier really just wanted so if Javier really just wanted and if you have any questions, feel free to email us. I know we didn't have a lot of time, so but feel free to email us with any questions you may have. So returning to our presentation, if Javier really wants everything, including the home, to go to his son Alexander, then Alexander will not get the home. Because the stepmom is a surviving joint owner of the home, she will get the home even if Javier's will says, I leave everything to Alexander. So, joint ownership overrides Javier's will. Then, if assets are not jointly owned, then the next thing I ask is, what does the beneficiary designation say? I'm willing to bet that you have beneficiary designations at this very moment, whether you realize it or not. I'm Life insurance and retirement accounts are the best examples. If the beneficiary is living, like Alexander on the life insurance, then Alexander is going to receive that $1 million outright, even as a minor, even if Javier has a will saying otherwise. This is because beneficiary designations override Javier's will. Back to probate court. Plus, the probate judge doesn't have to choose Zachary as the conservator, even though he is named in Javier's will. Remember, the will is not legally controlling at this point. The document only attorney or the online software Javier used didn't tell him about this. He is rolling in his grave. And then, if there are any assets left over after we go through joint ownership and beneficiary designations, those assets go into Javier's probate estate. Javier's will now controls whatever assets fall into his probate estate, or if he didn't leave a will, state law says what happens to whatever assets fall into his probate estate. Here's surprise number one. Whenever you hear the word estate, it actually doesn't necessarily mean everything that you might own. It only includes those things that did not pass to a surviving joint owner or your designated beneficiaries. Sometimes people leave no assets that fall into their estate because the two levels above took care of their assets. And here's surprise number two. A will goes through probate court. A big myth is that a will does not avoid, or the big myth is the will avoid probate court, but it does not. Remember how we were at probate court when the life insurance proceeds were directly paid to Alexander? This is the same place we have to go to file a will when someone passes away. This means that even if a will, your family still has to go through probate court. Every probate court is public, which is how we can know about the celebrity estate planning mistakes uh, that the news that make news. Would you like to see the will of John Lennon, JFK Jr., Babe Ruth, Jackie Kennedy Onassis? You can, because they all went through the probate process. And if someone leaves no will, guess where we have to go? Still the probate court. Everything going through probate requires legal notices to all parties involved, even if a family member is disinherited. If you've ever had to go through probate court for a loved one, this will all sound familiar. As I worked with many families in the past, I found that there is an assumption that a will solves every estate planning problem you can think of. Well, it's absolutely critical that you have a will, and it's definitely not the only piece of your estate plan that you need. Now you're wondering, what do I do if I don't want my loved ones to have to go to court? Idea number 3. Javier gets a trust instead. And in his trust, he says, I leave everything to my son, Alexander, if he's under 21. I put Zachary in charge. You notice this is the exact same thing he said in his will. How does this work? First of all, let's address the elephant in the room. What is a trust anyway? The type of trust that we're talking about is a revocable living trust. There's all sorts of types of trusts out there, a lot of which serve a lot of different purposes. But the one we're going to talk about today is how to avoid the probate court. In other words, how can how can you say who gets what, under what circumstances, and make that happen, but not go through probate court? The revocable living trust is a will substitute in that it's like a will but doesn't go through the probate court. That's why it's a will substitute. Here are the 3 buckets in the context of a trust. We go through the joint ownership and beneficiary designation discussion. We have specific steps we take for each of your assets. We don't stop working for you just because you signed a trust document. We need to then take the steps to fund or put into your trust each of your assets, one by one. First, some of your assets we will update title from your name or your joint names to the name of your trust. Second, for other assets, we will update the beneficiary designations from naming, say, your minor children to the name of the trust. And third, there is no probate estate anymore. Everything you own is in the name of your trust, and your trust itself is a private document that says who gets what under what circumstances. There is no probate court because a trust is private, making it a lot easier and more efficient for the loved ones to handle everything. Now, I will clarify and say that whether you have a will or trust, if you have a disgruntled heir who's just been bent on causing issues for the family, then that is going to make things more difficult. Whether you have a will or trust, although there are more steps to take to challenge a trust over a will, a trust does at least discourage the not so serious, disgruntled heirs from doing anything other than maybe just complaining. Think of a trust and funding your trust like the toys in this little red wagon. When you were a kid, you loved putting the toys in your little red wagon and pulling it all around. And if your sibling wanted to grab your toys out of your wagon, there was probably immediately conflict or high-pitched voices. The way to avoid conflict and the exposure that comes with toys not being in your red wagon is the same with how a trust works. The probate court is avoided for the things you put inside of your wagon. The legal phrase for this is trust funding. And so as long as your assets are funded to your trust, meaning all of your toys are in the red wagon, then there is no probate court to get these assets passed to your loved ones. And this invites conflict. So look at this scenario. All the toys are outside the wagon. Here's what happened here. You signed a trust, whether in an attorney's office or something you bought online. Your trust legally exists. You signed it. Great. But your trust is the empty wagon. It's not avoiding probate, and it is inviting conflict. Would you send your child to their first day of school with a backpack that has nothing in it? Of course not. What good would an empty backpack do? You can see how this is a disconnect. We've got a trust, we've got assets outside the trust. This is not working. This is not going to avoid probate. This is a major danger with a do-it-yourself estate planning or working with a documents-only attorney. You must find your trust. Now, this is a much better scenario. The assets are inside the little red wagon. To bring it back to Javier, he has life insurance and he gets a trust. And he doesn't just leave it at that, he then updates the beneficiary designation on his life insurance policy to name not Alexander. This is what is causing all these problems. But to name his trust instead. Remember, we don't want Alexander personally to be named as a beneficiary because we don't want Alexander to inherit the $1 million outright. So Javier names his trust as the beneficiary of his life insurance proceeds. This means that when Javier jumps out of the plane and doesn't make it, the life insurance proceeds check is literally written to the Javier family trust, not to Alexander personally. The trustee of Javier's trust, his brother, Zachary, then deposits the check into a checking account in the name of the trust. And Zachary is immediately in charge of the funds for Alexander's benefit. Plus, Zachary doesn't personally own the $1 million. So even though he is managing it, because he doesn't own it, then the money is safe from Zachary's lawsuits, creditors, and ex-spouse. No probate court was necessary to make all this happen. No court, no conflict, and no delay. Lesson number 1. A review of all of your assets must be a part of your estate planning conversation. A document alone is not enough to protect you. Okay, that is everything that transpired from sad day number 1. I promise the lessons will not all take this long to cover. I wanted to cover the biggest question first, a will versus a trust. So thank you for hanging in there with me. If you have any questions, do write them down so we can cover those during the Q&A.